Good morning, Mr. Sarmiento.
Ese es señor Sarmiento.
You
Bien, señor Sarmiento.
were charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Si no puede ocupar una.
Yes, Judge.
We're to go slow.
Yes, Judge.
Más escuchen.
On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not have.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He doesn't know, he didn't say he know he stole it. He just didn't know him, did not give permission.
This exchange exposes a key flaw in the charge: intent. The judge presses on how a passenger could knowingly trespass if he didn't know the vehicle was stolen or even know the driver. Criminal trespass requires awareness, not proximity. Simply being present in the wrong place isn't enough. Without proof of knowledge, suspicion starts replacing law, and that's where cases fall apart.
You're telling me that he's in a car, he doesn't know the driver, and
Right, the complainant just said that in regard, he did not know the defendant, did not give.
I understand that, I get that, but so he's he's a passenger in a car, and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey man, you know.
Here the judge openly struggles with the logic of the accusation.
Yeah.
A passenger is being charged while the facts suggest uncertainty about relationships, permissions, and awareness. The court emphasizes that this isn't a strict liability situation. Specific intent matters. Without evidence, the defendant knew the car was stolen. The charge begins to feel speculative, stretching the law beyond what it was meant to punish.
So the trespass was the driver driving into the area, and he was this kind of.
He's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You gotta.
The prosecution tries to bridge the gap with circumstantial evidence: vehicle damage, a broken steering column, and the presence of a screwdriver. These details are offered to suggest any reasonable person would suspect theft. but circumstantial indicators still have limits. The judge weighs whether visible damage alone can truly establish knowledge, especially when everyday mechanical issues can look suspicious in hindsight.
Give me something that, it's a specific intent crime. You have to, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
Your Honor, further, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was, one moment,
a scratch on the hood.
signs of theft that would lead a reasonable and prudent person to believe the vehicle was stolen, as the steering column was broken in a manner